Spouse and I are going to divorce. She lives in Canada and I live in Michigan. Would she need to be here in America or in the state of Michigan where we got married in order to be divorced, or can we all do this online with both of us in our respective countries? Well, you do not need to reside in the same country or state to dissolve your marriage. Now note what I said. But whether that same divorce court can make orders pertaining to custody of children and support of spouses or children and or an ex-spouse or division of marital property is a different matter. See AMJUR Divorce, Section 170, Jurisdiction in Divorce Actions Generally. The two forms of jurisdiction involved in matrimonial cases are in rem jurisdiction over the marital status and in personam, or personal jurisdiction, over the individual spouse. An action for divorce is generally in rem as to the status of parties, and a court does not need in personam, personal jurisdiction, to grant dissolution of the marriage. Thus, to terminate marital status, a court presiding over a marital dissolution action must possess in rem jurisdiction over the marital res, in addition to personal and subject matter jurisdiction. As a general rule, however, the court may not enter a judgment adjudicating economic, child custody, and child support rights of the parties until personal jurisdiction is acquired pursuant to statute or by consent, although there is authority to the contrary. Personal jurisdiction may be acquired over foreign nationals if the appropriate minimum contacts are established with the forum state, in other words, where the divorce is being filed. See also 24 AMJUR 2nd, Divorce and Separation, Section 180. Under, quote, long arm, close quote, statutes, in personam jurisdiction may be acquired over a non-resident defendant or respondent in a divorce action by extraterritorial personal service of process made in accordance with statutory requirements if there are existing sufficient contacts between the defendant or respondent and the state relevant to the cause of action to satisfy traditional notions of fair play and substantial justice. Long-arm jurisdiction over non-residents in divorce actions is limited by the due process requirements of the 14th Amendment, which demand that the forum state have both personal jurisdiction over the defendant or respondent, as well as subject matter jurisdiction. For entry of a divorce decree, generally it is sufficient for jurisdictional purposes that the petitioner is domiciled in a United States jurisdiction, and it makes no difference what, if any, contacts the respondent has with the forum. However, financial orders, including those for child support, maintenance, and distribution of marital property, are considered to be in personam judgments, and for such judgments, the respondent must have sufficient minimum contacts with the forum for the forum court constitutionally to exercise personal jurisdiction over the respondent. However, in personam jurisdiction is not acquired where the plaintiff, or in this case the petitioner, fails to sufficiently allege in the complaint the basis for exercising long-arm jurisdiction under the statute.